Okay, very good.
This conference will now be recorded.
Okay, you're welcome to go ahead and start the meeting.
Thank you, Tessie. The time is 10:33 a.m. The October 14th, 2020 meeting of the State Medical Board will come to order with the following members present via video conference. Dr. Rothermel.
Present.
Dr. Safran.
Present.
Mr. Giacolone. Dr. Sloan.
Present.
Dr. Johnson.
Present.
Dr. Coccarello.
Present.
Mr. Ganadakis.
Present.
Ms. Montgomery.
Here.
Dr. Feibel.
Here.
Dr. Bechtel.
Present.
And myself, Dr. Schottenstein here. Thank you. Do I hear a motion to approve the minutes of the September 9th, 2020 board meeting as drafted? Motion?
So moved.
Dr. Safran and
Second.
Dr. Bechtel. Thank you. All in favor, voice vote, aye?
Aye.
Thank you. The board will now consider the reports and recommendations appearing on today's agenda. Has each member of the board received, read, and considered the hearing record, the findings of fact, conclusions, and proposed orders, and any objections filed in the matters of Shivangi Amin, MD, John Kavalich, MD, Mitchell Edward Simons, MD, and Gary Nicholas Spiritus, MD? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacolone?
Yes.
Dr. Stone?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Further, does each member of the board understand that the board's disciplinary guidelines do not limit any sanction to be imposed and that the range of sanctions available in each matter runs from dismissal to permanent revocation or permanent denial? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacolone? Mr. Giacolone?
Sorry, yes.
No worries. Dr. Sloan?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Does each member of the board understand that in each matter eligible for a fine, the board's fining guidelines allow for imposition of the range of civil penalties from no fine to the statutory maximum amount of $20,000? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacolone?
Yes.
Dr. Sloan?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. In accordance with the provision in Ohio Revised Code 4731.22 F2 specifying that no member of the board who supervises the investigation of a case shall participate in further adjudication of the case, the secretary and supervising member must abstain from further participation in the adjudication of any disciplinary matters. In the disciplinary matters before the board today, Dr. Rothermel served as secretary and Dr. Safran served as supervising member. In addition, Dr. Bechtel served as secretary and/or supervising member in the matters of Dr. Kavalich and Dr. Simons. During these proceedings, no oral motions may be made by either party. Finally, respondents and their attorneys addressing the board will be allotted 5 minutes to do so. The board parliamentarian will advise when the 5 minutes has expired. The assistant attorneys general will be subject to the same limitations. Please turn to the matter of Shivangi Amin, MD. Objections have been filed and were previously distributed to board members. Mr. Porter was the hearing examiner. A request to address the board has been filed on behalf of Dr. Amin. 5 minutes will be allowed for that address.
Good morning. My name is Todd Newkirk, and I represent Dr. Amin in this matter. I'd like to thank the board for their time and allowing us to address you today. I'm just going to make a brief statement and then turn it over to Dr. Amin. In August of 2019, Dr. Amin entered into a consent agreement with the Maryland board. Dr. Amin was required to complete some continuing education in prescribing and documentation. She completed those courses at the PACE program at the University of San Diego. She's in compliance with all other aspects of the Maryland consent agreement. The hearing examiner in this case recommended a reprimand, a fine, and probationary terms. And we have no issues with Mr. Porter's recommendation, with the exception of the fine. This is a purely bootstrapping action. She has never practiced in Ohio, and she's completed all the remedial action that Maryland recommended. So a fine here seems punitive in our opinion. And Dr. Amin asked that the board reject that recommendation. And with that, I'll turn it over to Dr. Amin.
Yes, thank you to the board for allowing me this time this morning. I agree with my lawyer, Claude. If there's one thing I regret is the 6 months I spent at that clinic early in my career, which seems like decades ago now. I do want to emphasize that I have renewed my Maryland license. I've been in full compliance in my home state. And I do also want to state that even though I had an Ohio license, I've never practiced there, nor do I intend to at all in the near future, as I don't live there. And so I would hope that you would take all this into consideration and remove at least the $3,500 fine, given the fact that I do not practice in the state of Ohio and I'm in full compliance in my home state in Maryland. Thank you.
Thank you. Does the Assistant Attorney General wish to respond?
No, thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Amin? Is there a motion?
So moved, Dr. Johnson.
Dr. Johnson, thank you. A second.
Second, Soin.
Dr. Soin, thank you. I will now entertain discussion concerning the matter of Dr. Amin. Is there any discussion? So I guess I have a couple of thoughts. I appreciate the concern about the fine. I think you could actually make a case that the doctor is getting off light with this order, given the nature of the prescribing that is alleged. But having said that, I also think you could make a case that that's justified because there are multiple mitigating circumstances. She's a young doctor. She has no prior disciplinary record. There's no dishonest or selfish motive. I think the situation is isolated and unlikely to recur. She's made full and free disclosure to the board. She's taken interim remedial measures, as well as multiple CME courses to try to understand the needs of her patients better while she was treating them. There's no adverse impact of her conduct on others of which I'm aware. I don't think her conduct was either willful or reckless, and she attempted to correct the misconduct by threatening to quit the clinic when she realized that she was in over her head. She contacted the patient's psychiatrist about weaning them off the benzodiazepines. She inherited these patients. She did not initiate their opioids. And she never increased anyone's opioid regimen. She's never practiced medicine in Ohio. She has no plans to come here. She's not writing any controlled substance prescriptions and has no plans to do so. So I think the order is fair and I agree with it. And I'm ambivalent about the fine. Any further discussion?
Dr. Schottenstein, we do have some board members who would like to comment. I think they're raising their hands instead of verbalizing. So,
very kind. You know what? My video is okay. Thank you. My video is somewhat frozen right now. I'm sorry. So if you'd be so kind as to let me know. So, Ms. Montgomery, go ahead, please.
I'm sorry, I didn't hear what your last sentence was. What was your recommendation? I couldn't hear you.
Sorry. So my thought was that the order was fair. I agree with it, but I was ambivalent about the fine.
Ambivalent about the fine.
Yes.
May I ask a question about, we are putting her on quote unquote probation for 3 years, I think, as a recommendation. And I'm not trying, I'm trying to figure out what we accomplish. We have over 200 people on probation now. This is, I'm just trying to figure out what do we accomplish by the probation, with regard to the fine, I too am ambivalent about it. So would rely upon other board members, particularly the docs, who have a sense of what we've done in the past and what's fair.
So I think that, just speaking for myself, I think the probation is number one, to make sure that she is compliant with her Maryland board consent order. And number two, it does require her to check in, with us in that regard. The prescribing was substantially concerning. And so I'm not opposed to the probation myself. And I also appreciate the thought in the order of the practice plan, if she should ever be inclined to practice here. Dr. Feibel, you had a question?
Yeah, I have two comments. One is about the fine, and I understand that she had a bootstrap action and she was reprimanded in Maryland, but it required resources of our board to investigate her because of her actions. And because of that, there are some costs associated with that. So I don't know whether $3,500 is appropriate, but certainly a fine is appropriate because of the time we had to take in investigating her. I appreciate that she's been forthright with the board, and I appreciate that she's not planning to practice in Ohio. But along those lines, should she choose to practice, I believe that during her 3-year probation period over the next 3 years, she should not be able to prescribe controlled substances in the state, similar to what the Maryland order had outlined for her in Maryland. And then once she's established practice here and is established that she can continue to practice good medicine, I think that can be lifted after 3 years. So I don't know whether that becomes part of her practice plan ultimately, or whether that's part of this order. But if anyone else would so desire, I would support that.
So I think we'll probably, Dr. Feibel, need a motion for that, because I don't think it's necessarily implied that it would be part of the practice plan. So it sounds like Dr. Feibel is making a motion to.
Well, I'd like to hear what everyone else said before I do it.
Okay, my pleasure. And again, you'll forgive me that I can't see hands right now. If anybody'd like to speak up.
Dr. Bechtel?
Thank you.
To comment, I think probation is appropriate. I think the really critical piece of this is the practice plan. Dr. Mean did not complete a residency after 2 years of her family practice residency. She elected to leave and focus on business. And it became obvious, early on in her career that she got in over her head with the opioid situation, not really understanding the situation to the extent she should have, and not tapering medications. And I think that the practice plan is a critical piece of all this if she would plan to practice in Ohio. And I think the 3-year probation is appropriate. I'm, like the others, kind of ambivalent on the fine.
Thank you, Dr. Bechtel. Is there further discussion?
Yeah. Hi, Dr. Swain here, if I may. I have a couple of comments. First of all, I support the order of reprimand and I support the order of a fine as it stands. I have some opinions that I'd like to discuss about the case in particular, because I feel like it's important also for Dr. Amin going forward to understand my rationale. And I understand some of the arguments, right? She was young. This was one of her first jobs, fresh out of residency. But being young and naive is certainly not an excuse for not meeting standard of care. And it's so interesting when you think about it philosophically. And you guys know this. I mean, Medicare pays the same fee schedule whether you have graduated one day after fellowship or have 30 years of experience, whether you went to Harvard or you went to med school in the Caribbean. And they do that because they assume that you're meeting what is determined to be a standard of care. And there's some things in her background that aren't interesting, right? I mean, she's not board certified in any specialty, so family medicine doctor, and elected to chose to take a job working at a pain clinic where, incidentally, she was the only physician there at the time, sometimes prescribing these high dose opioids. And that just seems like just a very strange pattern of decision making to end up in that situation. She tried to do some things to mitigate those, but that whole decision-making process is a little suspect. There's some points of the R&R that are interesting, and particularly looking at the Maryland board order, like on page 4 of the R&R, there's some sub-points about things that she failed to maintain in 4 out of the 10 records. And some of the stuff is interesting because I don't even know if it's necessarily good or bad. And I realize there's some observations, right? Like a subpoint E where they say the respondent failed to obtain updated imaging studies or other clinical indications of the patient's pain. I could see scenarios where patients are chronic, they've been around forever and nothing has really changed symptomatically. In which case, you're continuing the opioids. I just don't know why you need to update it if there wasn't any change in the actual position and situation, because that happens all the time in patients that are on chronic long-term pain medicines. And subpoint F that says you failed to taper or wean from excessive dosage of opioids in spite of lack of functional improvement or pain control over extended periods of time. That's a really funny thing to complain about when it comes to chronic pain patients, because there is a mountain of clinical data that shows there is very little functional improvement or pain control improvement over time, just because of the way the body sort of equilibrates the opioid. And so it's really tough to punish someone for something like that. And then moving on to page 6, there's a section about CDC guidelines, and she's a primary care physician, and there are these guidelines that came out saying that you shouldn't prescribe more than 50 milliequivalents of morphine in any patient, according to the CDC. And of course, those are us rules. There's more guidelines, and there's a lot of room for physician discretion in those. But at the end of the day, when I look at the fact pattern in all of this, it's just a reprimand, right? This isn't a major, issue considering how we've handled similar cases for prescribing in the past. I think it's a relatively fair order. I'm fine with the fine of $3,500. It's in our rules. It's how this is typically done. This is in line with that. I appreciate that she may have some mitigating circumstances, but at the same time, we have these rules and things for a reason. I support a practice plan. I like that she's not currently prescribing controlled substances. I'm sure if she had to, in the auspices of being a family practice doctor, controlled substance prescribing may be required in certain situations, because now anything that's a CNS depressant that's new is getting a scheduled label. So even if you're treating a pediatric patient with a seizure disorder, you may have to prescribe scheduled substances or controlled substances. So I understand how there may be some here or there, but I certainly don't recommend it for the practice of pain. In Ohio, we have rules and guidelines that prevent this type of behavior from happening in the future. So, for example, you can't be an only physician in a pain center or prescribing over 50% opioids to patients in that type of setting as the only physician, unless you have a terminal distribution license category 3 from the Board of Pharmacy, and unless you have a responsible person that is a board certified pain management physician that is on site and overseeing the care. So to that extent, I feel like in terms of risk to Ohio, there's some mitigation going forward. I agree that there was not criminal intent and there wasn't anything sinister necessarily that went on, but I also feel that there is some practice patterns and things that are not acceptable, and using youth and naivety as an excuse is not exactly acceptable, but the order itself is not super heavy-handed, being a reprimand and a fine. So I support the order as is.
Thank you, Dr. Swan. Is there further discussion?
Michael?
Yes, sir. Mr. Jeffrey. Mm-hmm.
Yeah, I think a lot of people made really good points. The only thing that concerns me is that this occurred in 2016, 2017. Opiate crisis is in full bloom, and this person steps up and starts handing out opiates like, it's Halloween here and trick or treat. This is the thing that concerns me, I think, the most is how did you miss that one? Where have you been in terms of what was going on? And the inconsistent urines and some of the other things that were prescribing. Yeah, okay, I get it. But how do you step into this? Blinders on. This is the thing that concerns me. And I think to Dr. Soy's point, youth is youth, but come on. I'm not driving a semi-tractor trailer because I can. I drive it because I don't drive it because I don't know what I'm doing. And you have a responsibility when you walk in there. So I guess I struggled. I think you got off light, quite honestly, with the Maryland board order. I really do. And I think I would support Dr. Feibel's position of, you come to Ohio, hopefully you don't, but if you come, you're going to be out of controlled substances for a while, because I just question your expertise in general. If you're naive enough to walk into this situation, and then after the fact, go, well, geez, I didn't know. How do you not know what's going on? How people are dying, being addicted out there, and continue the process? This is where I struggle. So I would support Dr. Feibel's amendment to the order, and I'm ambivalent about the fine. Dr. Feibel, do you want to restate what you wanted to do, just so we're clear?
Sure. I would like the amendment to say I've thought about it a little bit. I don't know if this is legal. Kim, you'll have to tell us if this is okay. But maybe a 2-year probationary period when she comes to Ohio where she cannot prescribe controlled substances. Is that if she starts practice in Ohio at any time? Can that be part of the order?
Do you maybe want to do it as a practice limitation? That if she comes, it could have a temporary practice limitation about prescribing. And do you want to have it be prescribing controlled substances or prescribing opioids?
I would like it to be controlled substances, I believe.
Okay. All right. So a temporary practice limitation that if she comes to Ohio, she cannot, I think you could do it as part of the probation. So a temporary practice limitation, if she comes to Ohio, she could not prescribe controlled substances.
For 2 years.
For 2 years. Okay. Thank you.
For 2 years once she starts practice in Ohio.
So, Dr. Fadel, I just want to clarify the order right now is probationaries for at least 3 years. You want to shorten it to 2?
I was gonna mimic the Maryland board's 2-year prescribing prohibition. I don't want to shorten the probation to 2 years, but the Maryland, the prohibition against prescribing, I'd like for 2 years once she starts practice in Ohio.
Thank you for clarifying. So we have a motion from Dr. Fadel, and we have a second from Mr. Giacalone. And so is there further discussion regarding this matter?
Yeah, hi, Dr. Soin here again. I appreciate the spirit of the motion. I do not support it. I think it might be a little heavy-handed, and I'm just concerned that it might impact her ability to practice family medicine for things that are non-opioids. As I mentioned, there are a lot of controlled substances out there that aren't opioids anymore. In fact, as I mentioned earlier, literally any new drug that has any potential CNS depressant activity ends up with a Schedule 5 designation, and technically that's a controlled substance. So, kind of limits her from being able to practice, in other ways too. That's just my opinion there.
Thank you, Dr. Soin.
Can I ask a quick question? If we say, Dr. Soin, if we say Schedule 2 or Schedule 3, would that change it?
That would solve the problem.
Okay. I'm okay with Schedule 2 or Schedule 3 narcotic drug.
So do you want to say Schedule 2 and Schedule 3?
Yes.
Okay.
Are you okay with that amendment, Bob?
Yeah, I'm cool.
Okay, does anyone object to a change of the amendment?
We haven't voted on it yet. So.
Right. I just want to double check the
motion.
Yes, Dr. Schottenstein is correct to make sure that no one is objecting to the change in the motion. Thank you.
Thank you. Is there further discussion? Okay. Hearing none, let's have a roll call vote, please, then, on the amended order, the order as amended, in the matter of Dr. Mead. Roll call, please, Dr. Rothenberg.
Dean.
Dr. Safran.
Abstain.
Mr. Giacalone.
Okay.
Sorry, yes.
All right, unless we have a lag time. Yes, please.
Dr. Soin.
No.
Dr. Johnson.
Yes.
Dr. Cacarella.
Yes.
Mr. Ganadakis.
Yes.
Ms. Montgomery.
No.
Dr. Feibel.
Yes.
Dr. Bechtel.
Yes.
And myself, Michael Schottenstein, yes. Thank you. So before voting on the motion to approve and confirm as amended, is there any further discussion? Okay, roll call, please. Dr. Rothenberg.
Sorry, Dr. Schottenstein, we need a motion. We'll need a motion to approve as amended before the vote.
Thank you very kindly. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended with the note of Dr. Moon?
So moved.
Cabral.
Second,
Dr. Carrell, thank you. Dr. Bechtel, thank you. Okay, so before voting on this motion to approve and confirm as amended, is there any further discussion? Okay, roll call please. Dr. Rothermere,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Sullivan,
No.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Gunadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
yes.
and myself, Michael Schottenstein, yes. Thank you. That concludes the matter. Please turn to the matter of John Cartledge, MD. No objection to a file. Ms. Lee was the hearing examiner. A request to address the board has been filed on behalf of Dr. Kavlich. 5 minutes will be allowed for that address.
Hello, I appreciate the opportunity to address the board. I am sorry that I did not comply with my original consent agreement that was signed by me back in October of 2018. At the hearing in July of this year, I did my best to explain the recent steps that I have taken and also circumstances why I did not completely comply with my consent agreement in October of 2018. Due to financial circumstances, my email, my office phone, and even my cell phone were turned off. Any notices that I had from the board was going to my office email, which was turned off about 2 months after my license was suspended. I hope that the board adopts the recent order containing the terms. However, consider waiving the $1,000 fine, considering my extreme financial situation right now. My house is in foreclosure. I'm currently living at my parents' house. Or I would like to utilize the $1,000 to apply to my treatment as stipulated by my consent agreement. Either way, I respect and honor the decision of the board and continue to meet the conditions for my reinstatement as stipulated in my consent agreement. Thank you.
Thank you, sir. Does the Assistant Attorney General wish to respond?
Good morning. I would just like to say that the state supports the report and recommendation for Dr. Kavlich. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Kavlich?
So moved. Soin.
Dr. Soin?
Second, Dr. Johnson.
Dr. Johnson, thank you. I will now entertain discussion concerning the matter of Dr. Kavlich. Is there any discussion? Ms. Montgomery.
Only one comment, and that is that we went several years without doing anything in compliance on this. It's pretty surprising to me that we went as long as we went before we discovered that nothing had been done, or we, at least from what I have here in front of me, our compliance, that's on us as a medical board. I know we're going to address it going forward. And as for the R&R, I would support the R&R.
Thank you, Ms. Montgomery. Is there further discussion? Again, if you'll speak up if you have any, because my video is frozen at times. I guess I have a couple thoughts. I think when Dr. Kavlich was originally placed in this one consent agreement, his mental health issues were such that he really was not ready or able to comply with the terms. It appears he's found a psychiatrist with whom he's comfortable, and he's started psychotropic medication and he's doing better. I'm glad to take him at his word that he feels ready to work through the consent order reinstatement conditions. I think the proposed order is fair. I don't see a point in attaching other conditions to his reinstatement. I just think he needs to comply with the consent agreement that he's previously agreed to. My initial thought was that the fine was fair because he did violate his agreement. Again, I'm certainly open to having a conversation about that. Any further discussion? Okay. Hearing none. Maybe we'll have a roll call vote then, please, to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Kavlich. Dr. Rothermere, please.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sullivan.
Yes.
Dr. Johnson.
Yes.
Dr. Kakarala.
Yes.
Mr. Gunadakis.
Yes.
Ms. Montgomery,
Yes.
Dr. Feibold,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Thank you. Please turn to the matter of Mitchell Edward Simons, MD. Objections have been filed and were previously distributed to board members.
Dr. Kavlich. Sorry.
I'm sorry?
I just wanted to thank Dr. Kavlich. So.
Thank you, ma'am. Thank you, Ms. Montgomery. That was very kind of you. A request to address the board has been filed on behalf of Dr. Simons. 5 minutes will be allowed for that address.
Good morning, everyone. My name is Greg Tifosi with the law firm of Dinsmore & Scholl, and we represent Dr. Simons in this matter. We'd like to start out by thanking Ms. Lee for her detailed report and recommendation in this case. But as we may or may not be able to tell, within the report and recommendation, this is not a pill mill case. We have a physician who worked to reduce all of his patients' reliance on opioids. We used a multidisciplinary approach that involved multiple modalities of treatment. He used both controlled as well as non-controlled medications. He adjusted those medications as well. He also adjusted the frequency of visits, referred patients for MRIs and x-rays, and communicated with specialists as well. So there's even more that we could talk about as far as what Dr. Simons did in this case that we don't see in typical pain management cases. But I think it's important to kind of take a step back and look at the time frame or the context of Dr. Simons' actions here. We go back to 2010, 2011, 2012, and even 2008. House Bill 93 was not implemented or effective until June of 2011. So we have Dr. Simons who was meeting these requirements before he was even mandated by law to do so. So really, we need to think about the standard of care from 10 years ago, and that's what our primary objections are in regards to Dr. McIntyre's report on behalf of the state in this case. Not only did he apply portions of 2020 standard of care to this matter, but he applied his own standard of care that was unfounded and without regard to the board's rules in this case. Dr. McIntyre didn't work in a similar type of practice because he only does procedures at a practice owned by chiropractors. He also doesn't know about the board's TDD regulations, and he didn't know about how the board has codified its approach to red flags. So with that, I'll turn the remaining period of time over to Dr. Simons to address the board.
I would like to thank the board for giving me an opportunity to speak to you today. For the past 30 years, my philosophy in practicing pain management has been to utilize a multidisciplinary approach in which I consider the medical, psychiatric, and physical therapy modalities necessary to treat the most difficult chronic pain patients. As a result, my practice was actually one of the first in the nation to receive accreditation by the Commission for Accreditation Rehab Facilities in 1990. I continue to make these principles the bedrock of my practice today. Morphine equivalency is in my DNA. I do not believe opioids are appropriate for all patients because most private pain management practices have been purchased by health systems and do not take outside referrals. The most difficult patients are typically referred to my practice. Almost all these patients have been prescribed opioids by other physicians who merely write the prescription every 30 days and move the patient along without the proper workup. That is not my practice. I constantly strive to reduce my patients' reliance on opioids from the very beginning and begin to work out the pathologies that are causing the patient's pain. The patients involved in this case before the board were some of the more challenging patients I have treated, as their conditions were chronic and there were numerous behavioral or psychiatric problems involved also. However, I worked to reduce these patients' reliance on pain medications, adjusted the doses if clinically indicated, and constantly incorporated non-narcotic modalities such as non-steroidals, neuropathic agents in up-to-date interventional procedures. I've seen tremendous change in pain management field in the past 3 decades, and it is my duty to change my practice to correspond with these ever-evolving standards of care. That's why I respectfully disagree with the state's primary witness in this case. He applied 2019-20 standards to my 2008-2012 patients and does not have experience working with difficult chronic pain patients in a solo practice setting such as mine. 10 years ago, I did not always order urine screens for the patients at their first visit because I found patients prepare to be screened at their first visit. Of course, for my practice, has changed since then, and I now order screens at their first visits unless I have a documented clinical reason not to order the screen. I cannot stress enough the importance of monitoring for red flags, and I undertake that with all my patients. I understand the need for accurate documentation in my patient's record. While I did not specifically document that I address risk and benefits of opioids, I did utilize an opioid agreement with my patients that discussed these risks and benefits since 2005. Just like today, I can assure the board I've always discussed and evaluated such risk and benefits at every visit. I agree with that physicians, including myself, could always document better. I want the board to be aware that I've changed my documentation practices over the past 10 years to be more thorough, and I make sure to follow up on all red flags. One of the biggest criticisms in this case is that some of these patients should not have received opioids from me because they were terminated by other practices. However, these patients came to me dependent on opioids, often without their proper workup and diagnostics performed, which is needed to reduce the reliance on opioids. At the same time,
Dr. Simons, this is the board parliamentarian. Your 5 minutes have expired, so I'll ask you to conclude your thoughts, please.
Okay. Well, my practice, I have a compassion and I enjoy the multifaceted care for debilitating diagnoses, and I take care of those in my practice. I treat the patients referred to me because I truly love the practice of my practice and taking care of my patients. I look forward to providing the maximum level of care as standards of care continue to evolve.
Thank you, sir. Does the Assistant Attorney General wish to respond?
I do. Thank you, Mr. President. Good morning, members of the board. Looking at this case, my opinion on this is it was pretty serious, what we saw here. The majority of, or if not all of these 10 patients demonstrated numerous red flag behaviors. You know, they lost their drugs were stolen, they accidentally took a relative's drugs, they demanded more medication, they ran out of medication early, they had aberrant screens for drugs in their system. So I don't think Dr. Simons was being held to some unreasonable standard here. Dr. McIntyre, the state's expert, was clearly qualified. He is a board certified anesthesiologist, and he also had a specialty certification in pain medicine and completed a 2-year fellowship at the Cleveland Clinic in pain medicine. So I think that's just a red herring. I think this case can be summarized, I think, very well with at least looking at 2 of the patients more closely. Patient 5 came to Dr. Simons' practice in June of 2011 when he was 59 years old. In his initial visit paperwork, he admitted to having 12 alcoholic drinks a day. Dr. Simons prescribed this patient Opana from the outset of treatment, and in October of 2011 added Percocet. This patient's neurosurgeon noted in a record that's in the chart that the patient was over-medicated, and Dr. Simons' response to that was actually, he commented in the chart that was ridiculous. Any doctor, certainly one who claims he's an expert in pain management, would know that a patient who has that degree of alcoholism is not a candidate to receive powerful opioid medications. And yet Dr. Simons gave this patient such drugs. And this patient even later tested positive for cocaine and was still given limited narcotic prescriptions. Patient 2 presented to the practice briefly between September and November of 2013. Dr. Simons was aware that this patient had been arrested in the parking lot of his primary care physician for snorting Xanax. He also admitted to drinking 10 to 12 beers and passing out at night. Dr. Simons defended his actions to prescribe narcotics and benzos to these 2 patients, and quite frankly, all the patients, with seemingly no reflection on how dangerous this was, no admission that this was below the standard of practice. No matter if it's in 2000 or 2020, individuals with these type of red flags should never receive opioid medications. I don't agree with the recommendation of the hearing examiner. I believe at a minimum there should be a permanent restriction on this physician's ability to prescribe narcotics and benzodiazepines. I think that would make the penalty as it is recommended now more palpable in my belief. I also think the board could consider revoking this physician's license based on what we see here. Thank you.
Thank you. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Simons? Motion?
So moved, Dr. Cockrell.
Thank you, sir. Is there a second?
Second, Dr. Johnson.
Thank you so much. I will now entertain discussion concerning the matter of Dr. Simons. Is there any discussion?
Yeah, I have some comments I'd like to make, if that's okay.
Thank you, Dr. Sloan. Sure.
And if you guys could bear with me, I have a lot to say here today on this matter, because there are some nuances here that I think are important to realize and to understand. And I'm going to preface this by saying this is not necessarily a standard pill mill case of high prescribing, because what we were seeing back then were, typically similar medications prescribed on every patient with templated notes and all that here. And what you see here is an individualized practice plan with diagnostics and workups done. And we can debate about the nuances about what prescriptions were chosen when, but there's one key point I want to talk about to start with here. And that is the state expert witness, Dr. McIntyre. And I understand how difficult it is to get credible witnesses. And on the front, his resume and CV seems like he's a good guy, Cleveland Clinic and, pain management certified, and he'd be one that would seemingly be good for pain cases. However, Dr. McIntyre's practice is one more of interventional pain management, almost like a needle jockey doing injections, nerve blocks, that type of stuff over and over again. And his ability to comment or opine on patients that are high opioid users, or his experience in doing medication management, just may not be there. And I want to turn to some evidence from his testimony to prove my point. And if you look at page 76 of the R&R, he says, quote, "The patients in this set fall into this category, but they have displayed signs of addiction, abuse, misuse of medication. I think the decision-making is actually easy." He then goes on to say the standard of care dictates that these patients are not candidates for opioid treatment. And that was the case. That is the case today. That was the case 10 years ago. That was the case 30 years ago. If patients can't follow directions and take the medications as prescribed, they should not be taking these medications. They should not be given access to very dangerous, potential deadly medications. That's clearly his opinion, clearly the opinion of the Attorney General. But I got to tell you, I literally probably disagree with every single thing that was said in that testimony. And as a result, I just have a difficult time accepting Dr. McIntyre's testimony as being credible. The sentence that says, "I think decision-making is actually easy," is very irresponsible. In fact, that is the hardest decision we have to make as a pain management physician. There's nothing easy about those patients. And to blow it off as being an easy decision-making scenario is, I just find it fundamentally wrong. And then to go on to say that they should not be given access to very dangerous, potentially deadly medications, I have a problem with that too. And I have a problem with the Attorney General's opinions when they said patients with red flags should never be given these medications. So what does that mean, right? What are we saying here? And that's fundamentally what you have to decide. So if you have an impairment problem, an addiction problem, or if you have red flags or some issue, does that mean you have a scarlet letter and you're banned from access to these, that you don't have the same ability or same rights to get care or to get treatment that other people have? I don't think so. I think there could be ways and situations where there are red flags with appropriate documentation, guardrails, systems in place, monitoring, following, that it's fine and appropriate to write dangerous medications. Red flags are tools that point us in a direction to help us make decisions. That doesn't mean we can never write them an opioid or we can never take care of them. That's not how our rules are written. And if that's what the board wants or the state of Ohio wants, then make a rule behind it. A lot of this stuff is really old too, 2008, 2013. And I understand people are saying, well, that should never happen, et cetera. But standard of care has been a moving target. I mean, what is considered standard of care in pain management today was not standard of care when I joined the medical board. It was not a rule to check ORs on every patient when I joined the medical board. It is now. It's in statute now. If you don't do it, it's really bad, right? But if you didn't do it back then, well, it actually was kind of recommended. It was a tool that really wasn't actually reliable at the time, you know, those types of things. Same thing with urine drug screens. So here we have a physician who checked ORs on all of his patients before he wrote them opioids. That's exactly what we wanted them to do. He had documented history and physical exams on all of his patients. He actually documented the red flags. That's how you all find out about the red flags. Because a lot of times we'll find out red flags on these pain patients from other things that happen. But this doctor was open and upfront and recognizing these red flags and documenting them. Not only that, when a red flag occurred, he actually would make adjustments. Now, that is a debatable point about some of his decision-making when he made those adjustments. And I'm not going to defend those here because certainly I think an objective physician can look at those and make other decisions based on red flags that they saw. But he did make an effort to make some adjustments. So for example, there was a patient that had some red flags that came up and he switched them to a fentanyl patch. 25 microgram fentanyl patch, which is one of the lower doses it comes in, still a very potent medication. But the logic there was, hey, this isn't a pill, right? I mean, you can't snort that, so it's a patch. Now, I got to be honest, that's not necessarily the decision I would have done, or a lot of my colleagues would have done. But I can kind of understand why he was doing that. And the reason why I'm saying all of this is because I just want everyone to know, and I suppose Dr. Simons know, I don't think there was criminal intent here. I think that he was trying to advocate for his patients, that this is not a pill mill. Each patient had an individualized practice plan with different medications. They had some diagnostic workups that were done. And I understand that people were upset about patients getting opioids and benzos. And that is a very challenging thing for us pain doctors, because I know most pain physicians today, or for the past several years, typically do not write those together on new patients. But one problem that we have is one of the legacies from the opioid crisis from 10, 15, 20 years ago is benzos were written quite commonly, and they were written quite commonly with opioids. And weaning some of those patients you've inherited, which are some of the cases here, have been extremely difficult. Actually, one other thing I want to point out is you can wean an opioid, and a patient will get sick, they'll get withdrawals, it feels terrible, but they won't die. But if you wean a benzo, there's actually a threat to life because of the physiologic addiction, cardiovascular collapse, and that kind of stuff. And that really complicates the issues here. I'm not supporting it, but I'm just letting people know that. He checked urine drug screens on patients, and I understand red flags come from there. But if you look at our rules and our guidelines, we want people to check urines, right? And if you have a red flag, what is the actual rule, right? I mean, do our rules say that we have to wean all patients off of opioids? I don't believe it does. And if that's the expectation, then make that a rule. But don't punish someone for following the rule or guideline, which is taking the urine drug screen, and then the action after that not being exactly what you intended if the rule does not spell that out. In other words, he's trying to follow the rules and guidelines that we have here. Now, the end decision making may be a little different. And if you don't like those, then you guys, or all of us collectively as a board, need to be making rules to legislate those things. But I think it's difficult to punish physicians on the back end for those types of decisions that are made. For someone that did check ORs, did do urine tests, did order diagnostic testing, did individualized treatment plans. Now, taking all that into consideration, I think it is irresponsible to ignore these red flags, right? I mean, I can't deny that. I can't defend some of these decision-making processes that went on. I can't speak for any of those things that he did. I think that there needs to be some action taken here. Actually, when I was reading the documents, which took me a very long time, as I'm sure it took everyone a really long time, because there was a lot of information in here, probably the largest one I remember in years. I remember thinking, what is the hearing examiner going to do to this physician in terms of recommendation? And in my mind, reading everything, reading the red flags, the way the cadence of the document was going with Dr. McIntyre, I thought for sure he was going to have some sort of revocation or permanent revocation. But actually reading the order, I don't know how to word this, but I'm grateful, would be a good term, for the hearing examiner to come up with a final order that seemed to take into account these mitigating factors that I mentioned. It wasn't a revocation. So, I think that the 6-month suspension and all that, we can debate that now in terms of if that's, too much or too heavy, have that stayed or lessened. In light of the fact that we just, gave someone a reprimand for excessively high opioid doses and literally not even doing any of these documentation things that we ask our physicians to do. In other words, the person we just reprimanded, didn't even go to these levels that Dr. Simons did in taking care of these patients. And so that's an interesting point for me. But I just wanted, since this was such a big R&R and there's so many moving parts to this case and how we handle pain cases, what do you do when you have a physician that sort of followed a lot of the chronic pain guidelines and then you come to a point where you don't actually agree with the end decision making? I think it's irresponsible to ignore red flags. I think it's irresponsible to keep writing opioids with people that have these really significant issues, and that there is a high likelihood that behavior is going to repeat themselves, and that's dangerous for our citizens. So we have to do something here to send that message. But I just want to say it's not what you might think it is in looking at some of these pain cases. Thank you.
Thank you so much, Dr. Soin, for your thorough, thoughtful comments. Is there further discussion? Ms. Montgomery.
Dr. Soin, I've just, after plowing through hours and hours of reading that transcript, I was waiting for your very articulate response to help the non-doctor on the board. And I just have one question, and that is, I heard your observation about the expert troubles me also. But I have one question. When you talk about ignoring red flags, am I expecting too much as a non-doctor to say that when a doctor knows that you've got somebody drinking 12 beers a night and demonstrating a significant substance abuse, that what I found difficult to deal with is I didn't see any reaching out. It was like, go talk to your primary care doctor. I didn't see anybody picking up the phone. Again, it may have gotten nowhere. Picking up the phone and taking one more step to connect his patient with other help that he couldn't provide. Am I asking too much of a doctor to do that? Or, is that not in your wheelhouse? Because that is what troubles me, among other things, because I do think that this really comes down to a judgment question as opposed to an intent question. So I would ask Dr. Soin if I may, or any of the doctors on the board, because I would expect them to do that.
I would love to comment on that. And I agree with you. And when I was sort of giving my spiel, and I said, there are things that I just can't defend in this case, and we need to take action because of it. It is that fact right there, is the red flag issue. And sort of, I just think he could have done more or should have done more to protect that patient from themselves and to protect the public at large. And so I don't see a scenario where it would make sense we could go through this without some form of action here. But I do want to mention that that patient that has an alcohol problem and a substance use problem, if they have a legitimate pain issue, perhaps there could be a way where they get opioids, but it's controlled, monitored very closely. And there are situations and opportunities to do that. There are abuse deterrent medications that, sort of have some protective mechanisms. There's a pain pump option where a patient doesn't even have access to any medications. There's transdermal patches that, really have some abuse deterrence with them. And there's a lot of options, or dispensing like 1 day at a time or 3 days at a time or something. I mean, there's just a lot of concomitant, psychiatric support. I think the point I was trying to make is that just because there's a red flag doesn't necessarily mean that prescribing an opioid is the wrong choice. But what was the wrong choice with Dr. Simons here is some of the decision making in light of the red flags, and I can't defend those. And Ms. Montgomery, you're absolutely right. And as a response to that, I would say because of those issues, I think we're compelled to act.
Dr. Feibel.
Yeah, I appreciate also Dr. Soin's thorough comments, and they're very helpful as given your perspective from your specialty, and I very, very, very much appreciate it. I made a lot of my determinations not based on the expert in the case, but rather the record as you did. So I hear what you're saying about the expert, but I did make my decisions based on the expert in the case, and I too agree with the proposed order of suspension. I am concerned about the fact that the red flags were missed. And like the previous case, I'm going to recommend that the doctor is not able to prescribe controlled substances once he gets back into practice for a period of 2 years. I'd be open to the schedule idea of whether similar to what you had said before, although he is not a family practice doctor, so I don't know if the same issues apply. But I would support adding to the order that he cannot prescribe controlled substances for a period of 2 years once he resumes practice.
And so controlled substances 2, schedule 2-3, all controlled substances?
I don't have the same worries about the previous person because of the fact that this is not a family practice doctor. But I think to be consistent, we should do schedule 2 and 3 narcotics.
Thank you. So Dr. Feibel's made a motion. Is there a second?
I'll second for discussion.
Mr. Giacalone, thank you. I have a few thoughts. Oh, well, Mr. Giacalone, please proceed.
Yeah, actually, you make a compelling argument, and I'm not a physician. Looking at what was going on, these seem like very complex patients with histories, obviously not necessarily great histories. I guess the couple of things I struggled with, maybe you can help me with this, is it almost seemed like this physician felt that discretion was open. I mean, anything goes. If I say it is. And I kind of got that sense almost of an arrogance associated with it. And it kind of bothered me. It also kind of bothered me that I felt like he may have been stuck in time. He never progressed, with the evolution of the pain management model. So I guess here's what I struggle with is how confident are we that he's actually turned the page and we're on the right page now, and how do we make sure that happens? I agree, permanent revocation is not there. I mean, I am totally with you, and I'm just trying to figure out what is the balance, not so much for punishment, but to ensure that, he gets with the program. He realizes, it's, he didn't meet the standard care. I mean, even the things we count about, the urines, I mean, they were inconsistent. I mean, again, we can go through all the points. I don't think we need to belabor it. I'm just trying to figure out what is the right thing to do to put guardrails on him so that we don't end up again here, because I'm just afraid that, you know, we may let him go through the gate and then, God forbid, we're back where we started. So I guess that's my question to you, Dr. Swain, is, you know, what do we do to ensure that this isn't going to be a repeat and he's going to get forward further with the program now?
Yeah, that's a great question. And I do have a couple of just comments based on what I noticed in the record. One thing I want to mention is, you know, we knew there was an opioid crisis probably around, at least pain management physicians should have known that, probably around 2008 to 2010. But it really, from a legislative standpoint, really came to a head around 2012 and definitely 13 and beyond. And anything beyond 2013, really. I think if you are ignoring things at that point, I don't know. I think your sentiment is generally correct that we stuck in time. But keep in mind that some of the things actually were happening, you know, prior to 2013. Some of them happened in 2008. I suppose you can use that to somewhat justify some of his behavior. Now, having said that, there is so much here that's difficult to defend, you know, as hard as I'm trying to see his perspective, and I understand where he's coming from on some of these things. Some of the behavior is just impossible to defend, especially regarding red flag decision making. And I think my whole point of all of my talking today is that I could see scenarios where you have patients that have red flags that can still get opioids and it be okay if you follow certain steps. And I just wanted everyone to know that that is certainly my opinion. However, I also want it to be known that a lot of times those steps were not taken, which is why we're going to have to do something here. Because otherwise, I'm pretty sure these cases may not come before us if those things were documented and done properly. Regarding the limit on opioid prescribing, a little bit different here than the family practitioner case, because if I understand correctly, Dr. Simon's practice is primarily, you know, writing controlled substances and that stuff. And so that limitation would effectively prevent or severely impair his ability to practice for 2 years. And I'm just wondering if there's an opportunity with probationary terms or some other way we could monitor him closely without, you know, being the death knell to his practice. Although, looking at the fact patterns, and this entire case, I think one would certainly be justified to follow Dr. Feibel's suggestion. I think that could be a reasonable outcome as well. So that is just my opinion on the limitation.
Thank you, Dr. Sohn. If you'd be so kind, I had a few comments regarding this matter as well. And I really think from reading through the document and from our discussion today, I really think the whole inflection point of this entire conversation is the issue of addiction. I suspect if we took 10 random charts from the doctor regarding patients who are not prone to addictive disease, we'd be having a different conversation. We'd probably be saying, looks like he is managing these patients in a responsible way. I think where we are running into trouble is the doctor's approach to his patients who have addictive disease. And I do think it is below the minimal standard of care to prescribe chronic opioid analgesic therapy for the treatment of chronic non-malignant pain to a patient who has addictive disease. And I do think that's been true for some time now. You know, patients with addictive disease, as we know, they are at high risk of bad outcome with chronic opioid analgesic therapy because of the substantial risk of diversion and abuse in this population. So to me, a high-risk patient, such as an addict, should be treated without chronic opioid analgesic therapy. If that high-risk patient comes in the door already on opioids from another doctor, then that patient needs to be educated about the risks of opioids, and arguably those opioids should be tapered. Current or past addiction to opioids is arguably an absolute contraindication to chronic opioid therapy. Cocaine use is arguably an absolute contraindication to chronic opioid therapy. Current or past addiction where opioids have never been involved is arguably at least a relative contraindication to chronic opioid therapy. So we don't withhold opioids from patients with addictive disease who have chronic non-malignant pain to punish them or discriminate against them, or because we don't want to help them. It's because it is doing harm to them. It is doing harm to society because they divert the opioids and create other addicts. I think the doctor turned a blind eye to the obvious addiction in his patients and just focused on treating the pain. In his attempt to help these patients, which I do think was genuine, I think the doctor lost sight of the fact that our first admonition is to do no harm. And because of the clear red flags for their addictive disease, these are patients to whom prescribing opioids is inevitably and foreseeably harmful. And people have brought up patient 5 already. At his first office visit, patient 5 indicated he was taking Percocet, Vicodin, and Ambien and consuming 12 alcoholic drinks per day. The doctor testified that the patient reported that if he had help with his pain, he wouldn't drink as much. And it appears that seemed reasonable to the doctor to prescribe opioid medications with the thought that as the patient's pain level reduced, that the use of alcohol would as well. The problem is that this is not how addiction works. Patient 5 arguably had an addictive brain. So when you have an addictive brain, each potentially habit-forming substance increases the overall craving for and dependency on every other habit-forming substance. So the effect of providing opioid medication to someone with an alcohol dependency is that the patient is going to drink even more, not less. The alcohol increases the craving and the dependency for the opioids. The opioids increase the craving for and dependency on the alcohol. So it does pain me to say it, but I don't think the doctor understands addiction. I don't think he prioritizes it as a focus of treatment in his patients. I think he prioritizes the pain control. And in doing so, I think he's done a disservice to his patients who have addictive disease. So that all said, I think that a permanent revocation is not indicated. I do think that if we restrict his practice so that he can't prescribe controlled substances, it essentially is the same thing as taking him out of practice. If there's a thought that we would like him to have additional remediation because, he did, he does have to take a controlled substance prescribing course, and I think he's signed up for the Cleveland Clinic course, which has a lot of education regarding addiction. But if we wanted him to be more substantially remediated, there's always the option of going through a physician reentry program like CPEP or PACE or something like that, where he could get, additional, remediation in terms of his knowledge of addiction and in terms of his prescribing. So I just wanted to throw that out there as an option. And I also want to just say, if I may, that, I appreciate Dr. Sohn's point. Sometimes, maybe there are times when somebody with addiction, legitimately would need medication of this nature. It's hard to be, so inflexible in situations like this. But I also appreciate his point, which I totally agree with, which is that it needed to be occurring in a much more controlled setting, almost like a methadone treatment program for substance abuse, where you basically go to a center and get your prescription every day. He prescribed, and forgive me, I don't mean to get off on a tangent, he prescribed a lot of methadone. And in 2009, according to the CDC, methadone was 2% of painkiller prescriptions in the United States, but it was involved in over 30% of prescription painkiller overdose deaths. So of all the prescriptions, of all the opioids to prescribe to an addict, arguably the most dangerous by far. And so, again, I think the doctor's education needs remediation in this regard, with regard to the topic of addiction. Thank you. Any further discussion about that? Mr. Jacqueline?
One question just to follow up on that. I was thinking physician monitoring program, is that a possibility? Because the courses are the courses, they're getting stagnant in time. I'm just wondering if, even that's even feasible given his specialty. Maybe that's not even an option too. Maybe that's just as non-doable. But, that might be another way to somebody who monitors what he's doing over a set period of time to make sure he's with the program. Is that perhaps an option we should consider? I'm just throwing it out there.
Thank you, Mr. Jacqueline. Dr. Sohn, you had your hand up.
Oh, yeah, thank you. Just a couple of follow-up comments. And first of all, I really appreciate and really generally agree with your entire testimony, Dr. Schottenstein. I want to mention one thing about addiction that's happening recently. just for some color of the situation. And then I want to talk about methadone briefly, because there's a nuance there that I think people need to understand. Regarding addiction, one problem that we're facing now as pain management practitioners is this whole thing with heroin, right? And some people turn to heroin because of opioid abuse. On the other hand, some have turned to opioid abuse because prescription opioids may be easier to get than heroin in certain situations and all that. But we have these situations where people have real pain and they are taking, these addictive drugs as well, and they have an addiction disorder, and then they have chronic pain issues, and we're challenged to balance that. Now, in those situations, though, typically it's done with a multidisciplinary team. Almost always, if someone's a real bad addict, it's done in a situation where that particular addict actually doesn't have access to opioids in terms of either some special way to dispense it, either it's abuse deterrent, and in most cases or in some cases, I'd say, where the addiction is a very severe issue, as we've seen in some of the ones here with Dr. Simons, they actually end up, if they really are candidates for chronic opioids, with like an implantable pump where they have zero access to any ability to dose, titrate, or use the opioids. And I guess I'm making that point in case further things come up that there could be situations where there's a red flag of addiction, and these are unique cases where chronic opioids are prescribed, but it's in a very controlled environment. The second thing is methadone. There's something really interesting I want to mention about methadone. Oftentimes people that have addictive disorders end up on Medicaid because their lives go sideways. They spend all their money on drugs. As a result, they don't have health care, so they end up on the Medicaid system. And up until recently, as recently as 2016, the number one preferred drug on the Medicaid formulary was methadone because it's so cheap. Right? For $1, you can get literally a month's supply. And as a result, that was literally one of our only options for patients that needed pain medications. And by design, it sort of steered a lot of these people into getting methadone, which is an incredibly unsafe drug due to respiratory depression, dose stacking, prolonged QT interval, which can affect the heart. It is literally responsible for so many accidental overdose deaths. And that was a problem we had internally with how the state was running things. Of course, the state recognized that and has subsequently fixed the formulary. But I do want to provide some defense for the use of methadone in some of these patients that predated that date.
Thank you so much, Dr. Sohn. Is there further discussion? So we have an amendment on the, forgive me, Mr. Jekyll.
Yeah, just again, I'm trying to understand how do we make sure, Dr. So you make a great point about the pumps and everything, but I still feel like this guy's stuck in time. How do we get him to move forward with time and realize, that, how do we get him on the track? And I'm still not feeling we have a solution here, because the solution is, we take away the controlled substances, that effectively puts him out of practice, right? That's what's going to happen. I prefer not to do that, but I'm trying to figure out how do we get him moving in the right direction and ensure that happens. And I'm still, a fine and suspension, I'm not sure that gets him to where we need to be either. It's punitive perhaps, and I'm looking at the long game, not the short game here. I'm not sure what that is yet still.
Yeah, that's an excellent point you bring up, right? So we have punitive damages or whatever, punitive punishment, but we need effective remediation too, right? So that's a great point. And I don't know how to get there, but I just wanted to articulate that. Effective remediation is the ultimate goal.
So if you all are so inclined, there's the option of, a physician reentry program like CPEP or PACE. We've sent other licensees to those programs. They're pretty intense and thorough. And so if we're not comfortable, understandably, with, let's say, the bare minimum kind of Cleveland Clinic course, even though it is a great course on controlled substance prescribing, we certainly could request that more intense level of remediation. And maybe that would be, satisfying. Dr. Feibel.
Yeah, is there nothing else he can do during practice other than prescribe controlled substances? Is that the entirety of his practice?
Yeah, I don't know that point. There are so many options. Like if you look at Dr. McIntyre, the state witness, I mean, probably 95% of his practice is non-opioids, right? Yeah, you're right. I mean, there certainly are other modalities for pain management.
I just think it sends the appropriate message to him that he really needs to take it seriously once he gets back into opioid prescribing. And it doesn't completely take his ability to practice medicine away like a suspension for 2 years would. And so, again, I appreciate everything that's been said about the mitigating circumstances, but he ignored a lot of really dangerous things that are unjustifiable, in my opinion. And again, taking away the opinion of the expert, my opinion as an orthopedic surgeon who doesn't do what he does, but certainly prescribes a lot of pain medicine. I would not prescribe pain medicine to somebody who had a positive toxicology. I would not prescribe pain medicine generally to somebody who drank 12 beers a day. I mean, it just wouldn't be part of what I did, and I'm not trained in that area. So I just think he fell so far below the standard of care. Again, I don't think a permanent revocation is necessary, but I do think we need to send a very serious message that this is not okay.
Thank you, Dr. Feivel. Further discussion? Okay, so we do have an amendment that's been seconded. And so we can certainly have a roll call vote if you're so inclined, if you'd like. So roll call, please, Dr. Rothenberg.
Dr. Schottenstein,
yes.
Can you detail the amendment before we start voting on it, just so everyone's, so I just want to, a lot of iterations have come through. I just want to make sure I understand what we're voting on.
Yeah, of course. Kim, did you take those notes? I thought I saw you. I mean, my understanding is it's a temporary 2-year prohibition on the Schedule 2 and Schedule 3.
Yes, that's, so I have that the order is as is. I think one thing I'd like to ask you, so you would have a 2-year restriction on prescribing, administering, Schedule 2 and 3 controlled substances. Do you want to make that part of your probationary, like after reinstatement, make that part of the probationary terms? And I would just note, you don't have a practice plan requirement in this proposed order. There's a monitoring physician requirement, but not a practice plan.
So if I could, I would
restriction
like,
part of the practice plan is what I'm asking.
Yes, I would, and I would like to make him have the wording that we use, the typical wording we use for I don't know exactly what it is, but to have a practice plan as part of his probation as well. And again, I'll add that to the amendment, assuming no one has any issues with that.
Okay, and I also just want to clarify, as was in the record, there is a 2006 permanent restriction with respect to having a chaperone in the practice, and you would want that would continue. You would want that to continue as is.
Yes, and I will say real quick that we didn't even bring that up in this deliberation, but that is on our end a red flag to me as well about things and how he practices medicine. And so again, that just makes me stronger in my opinion that he needs this 2-year prohibition.
Thank you, Dr. Feivel. Any objection to the modification of Dr. Feivel's amendment? Okay, thanks very kindly. So thanks, Kim. If you'd be so kind, then let's have a roll call vote on the amendment. Dr. Rothenberg.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
No.
Dr. Soin.
No.
Dr. Johnson.
No.
Dr. Cacarella.
No. Yes.
Mr. Ganadakis.
No.
Ms. Montgomery.
No.
Dr. Feibel,
Yes.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, no. I think the amendment fails. Is there further discussion? Mr. Jacqueline?
The PACE program that you suggested and the intensive, I think we need to, at a minimum, we need to put that in we do for him. We need to put that on the table in terms of addition to the proposed order.
So perhaps, and again, I can't make a motion as president, maybe if you're so inclined, a physician reentry program of that nature that would substantially address remediation in the area of addiction and potentially the practice monitor.
Yeah, I would propose that.
Yeah, and also,
Okay, so,
of course, including the practice plan and the chaperone issue, right? You'll bundle that all in.
Yeah.
Thank you. And so is there a
Can
second
I
on Mr.
clarify,
Jacqueline's? Yes.
or do you need to get a second?
It'd be more proper to get a second before clarification.
Okay.
So, okay, so forgive me. So is there a second for Mr. Jacqueline's amendment?
Second, Dr. Johnson.
That's Dr. Johnson. Thank you so much. Further discussion?
Can I just clarify that you want the physician reentry program to happen, like the evaluation to happen as a condition for reinstatement?
I think that makes sense.
And then follow the recommendations of the program. I think that's our typical. Okay, thank you.
Amol, is that good with you? Okay.
Great. Dr. Feibel.
All I would like to say is that with all the mitigating circumstances and everything else, I think this is a very light punishment for the behavior that occurred. And I think we as a board are setting a lot of precedent here. And it worries me, the precedent that we're setting about a very egregious, again, there are mitigating circumstances, and I agree that permanent revocation is not necessary, but we should be close to that with this issue, especially given the fact that that he had a previous action that required him to have a chaperone in the room, which is a very serious thing in and of itself. And it worries me, the precedent we're setting with this. We've been much stricter on other practitioners who have done much more egregious things. And I will tell you, this medical board, and granted it was a long time ago, but suspended one of my partners at the time for 6 months for a way much less egregious issue than this. And that's all I'll say.
Thank you so much, Dr. Feibel. Thank you. Dr.
I would like to comment on that point as well. First of all, point well taken, Dr. Feibel. And just my only general comment is I want to stress at how severe and how significant this board takes into account prescribing, and particularly opioids. It's something that we take very seriously. And for cases going forward, we're certainly going to take those very seriously as well. This was a very significant case where there was just a lot of information to digest here. And there were some other aspects that made this case a little bit difficult, particularly with this expert witness, et cetera, that did sort of change things a little bit for me. And on the same token, earlier today, we only reprimanded somebody that had egregious prescribing on 10 patients also. And I think it's one of those things where we sort of look at it on a case-by-case basis. I am certainly not defending the behavior that was done here. And I think that it absolutely warrants some significant action. And going forward, I think I don't want to set a precedent here with this particular case that every fact pattern will be taken in consideration as we deliberate future cases. And there may be situations where we revoke licenses for things that people may perceive as being less egregious, but the actual reality is when you peel back the onion and look at the fact pattern that there are reasons for that.
Thank you so much, Dr. Stone. Is there further discussion? So maybe we'll have a roll call vote on the amendment then, please. Dr. Rothermel?
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Soin,
Yes.
Dr. Johnson,
Yes.
Dr. Kakarala,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
No.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Do I hear a motion to approve and confirm the proposed findings of fact, conclusions, and order as amended in the matter of Dr. Simons? Motion, please.
So moved, Dr. Johnson.
Thank you. Second,
Second.
Mr. Giacalone, thank you so much. Before voting on the motion to approve and confirm as amended, is there any further discussion? Roll call, please. Dr. Rothenberg,
Abstain.
Dr. Safran,
Abstain.
Mr. Giacalone,
Yes.
Dr. Soin,
Yes.
Dr. Johnson,
Yes.
Dr. Kakarala. Sorry, Dr. Kakarala? Oh, hi. That's a yes, I think. Mr. Ganadakis.
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
No.
Dr. Bechtel,
Abstain.
and myself, Michael Schottenstein, yes. Thank you all so much. Please turn to the matter of Gary Nicholas Spiritos, MD. Objections have been filed and were previously distributed to board members. Ms. Szymanski was the hearing examiner. There has been a last-minute request for continuance, and so I'll turn that over to Ms. Anderson, please.
Sure. This morning, we became aware that Dr. Spirito's counsel has requested to move consideration of the report and recommendation to next month. In your materials, you should have an email from Mr. Newkirk representing the doctor, and also an email from our AAG, Ms. Snyder. So I don't know if I think it might be a good idea to hear from both about that motion. Typically, these are decided by the board president when the board is not in session, but the board is in session today when we receive this. So the full board will decide this.
Thank you, Ms. Anderson. So is Mr. Newkirk available? Would you like to go ahead, sir?
I am. I don't know what more I can add to the email I sent this morning. As you may know from the record, Dr. Spiritos has had a number of health issues over the last few years. The one remaining issue that he hasn't had addressed yet is his back issues. He was unable to attend the administrative hearing, but we agreed that it was very important that he appear in person before the board today for its consideration. As such, one of his relatives was driving up to pick him up to bring him to my office to appear before you. Yesterday, he picked him up. He was unable to make the trip because of his back, and that plan was aborted. So at that time, I told him that given the late notice, that I would just need to appear on his behalf. This morning, he was a very strong opinion that we should ask for a continuance until next month. So that is the reason for my email and the late notice. So I think it would be beneficial for this board to see him in person. He poses no risk to the public at this point. He's not practicing, nor is he able to. So I will leave it to your discretion as to whether this needs to go forward at this meeting, in which case I'm prepared to go forward, or if in the board's discretion, it would be appropriate to push it back a month to when Dr. Spiritos can appear personally. Thank you.
Thank you so much, sir. Does the Assistant Attorney General wish to respond?
I do. Thank you. I too would stand by the email that I sent, but I will note that Dr. Spiritos has been granted 3 continuances already. This site has been pending since July of 2019. It appears to me that he's using his health as a shield to prevent the board from kind of reviewing the other states' actions. And I think that there's no indication that his health is going to improve so that he can personally appear in the near future. And I think that had he, I think that he's known that his health has been an issue. His counsel could have driven up to him so that they could be together. And, you know, he has the opportunity to virtually appear. So that I would just stand by my objection to the further continuance of this matter. Thank you.
Thank you so much. Regrettably, I don't have the email that you said, but I gather the gist of it. So I thank you very kindly for that. So is there a discussion? And so, Kim, is this a situation where we vote?
Yes, I think you need to vote, and the issue is the motion is to grant a continuance of consideration of the R&R and move it to next month. Yes would be to grant it, no would be not to. And then if it's no, you would move forward today.
Okay, thank you. Any discussion before we vote? Or does anybody need more time to think about it?
You know, just for clarification, Michael,
May I ask a question?
I don't have this email. It's not an onboard. Do anybody else have this email?
Oh,
I'm sorry, it should have been loaded as the first item.
yeah,
I can
I
double check.
requested it. Yeah.
Okay, so I mean,
Yes.
it's just, you know, it'd be nice for us to read the email before we decide it. So can we get it?
So I have,
It's short if you want someone to read it to you.
Yeah, that would be fine, just as long as, because I don't have it. I just want to make sure I put the, you know, the reason here. I think I got Mindy's gist.
Dr. Schottenstein,
yes, Ms. Montgomery.
and I need to be clear on something. I believe that our first notice of hearing was in September of this year. Not that this hasn't been a long delay, but I just wanted, just for the record, to know that we just gave them notice of this hearing again in September. And I don't know if we've had notice of have there been other continuances? I don't have this in front of me. I just have a note here. Notice was in September. Have we had continuances on this hearing?
The AAG has indicated yes, and you do have the case record file. I guess I want to be clear. What you're talking about today is consideration at the board meeting. And yes, the doctor would have been aware of when he was required to appear at the board meeting through the service of the report and recommendation. So I think what the AAG was discussing was the hearing before the hearing examiner. But I can read the emails if you want me to.
That'd be great. Just as long as we know what
All
they
right,
say.
so the first one is from Mr. Newkirk. Says, my client has suffered from a number of health issues over the past several years. In fact, he was unable to participate in the administrative hearing in this matter. We felt it was important that he appear before the board today when it considers his case. Because Dr. Spiritos is completely unable to use a computer, he was planning to travel to Columbus to appear before the board virtually from my office. His cousin drove to Cleveland yesterday to pick Dr. Spiritos up and drive him to Columbus to meet with me and stay at a hotel in preparation for today's meeting. They made it about 30 minutes down the road before Dr. Spiritos' back, his one remaining unaddressed medical issue, made it impossible for him to make the rest of the trip. After being advised of the above, I informed Dr. Spiritos that I would just have to appear on his behalf. However, it has come to my attention that Dr. Spiritos would like to request a continuance of the board's consideration until next month's meeting. And that's signed Todd Newkirk. And then I'll read to you from the email from Melinda Snyder. So, good morning. The state continues to object to further continuances of this matter. The site has been pending since July of 2019. Dr. Spiritos has been granted 3 continuances of this matter already. His ability to practice medicine has been restricted in 2 other states in which he is licensed. At this point, Ohio is the only state in which he holds an active license. If he is too sick to travel, his counsel could have driven up to him so he could appear virtually. At this point, the board just needs to consider the report and recommendation and make a decision regarding Dr. Spiritos' active license.
Thank you so much, Kim. Any further discussion? Okay, so why don't we take a vote? Again, this is to grant the continuance until next month. Roll call, please. Dr. Rothermel?
This is Benton. Kim, I believe this is Benton. Pardon me. I believe we do need a motion from a board member to the effect of what Kim has said.
So moved.
I'm sorry, Kim, you're muted.
Yes, Dr. Cockrell, thank you. Is there a second?
Second, Dr. Johnson.
Dr. Johnson, thank you.
Thank you.
Thank
you very much.
Thank you so much, Ben. And so further discussion before we vote on the motion.
So Michael,
Okay, so the motion
to proceed.
The motion is to continue.
Okay.
Right, Kim, isn't that what you said?
Yes.
Continue the case or continue the matter hearing today?
Continuing.
A continuance.
To move it.
I'm sorry, I don't understand. Is this a motion to grant a continuance or a motion to deny the continuance?
It's a motion to grant the continuance.
Okay.
So
That's
that
correct.
we'll see you next month. Okay, great. Further discussion. Dr. Saffron.
Can we vote on this since it's not?
The secretary and supervising member cannot vote, and but Dr. Bechtel can vote.
Thank you.
Thank you. Further discussion. Okay. Roll call vote then, please, to grant the continuance until next month. Dr. Rothermel?
Abstain.
Dr. Saffron?
Abstain.
Mr. Giacolone?
Yes.
Dr. Soren?
No.
Dr. Johnson?
No.
Dr. Coccarella?
No.
Mr. Gonadakis?
No, sir.
Ms. Montgomery?
No.
Dr. Feibel?
No.
Dr. Bechtel?
No.
Myself, Michael Schottenstein, yes. So the continuance is not granted. And so we're going to take the matter today. Yes? Okay. Thanks very kindly. If Mr. Newkirk would be so kind then, a request to address the board has been filed on behalf of Dr. Spiritos. 5 minutes will be allowed for that address.
Thank you, and thanks for your consideration of that motion. Dr. Spiritos was originally licensed in 1989 and practiced without incident for over 30 years, for nearly 30 years. He's licensed in a number of states. He's never had any involvement with any medical board until 2017, when allegations were made in Arizona. And I'm not going to go into the motivations behind those because those are more a matter for Arizona. But the exhibits presented and the character references presented as respondents' exhibits in this case show that the allegations in Arizona are strongly disputed. However, because Dr. Spiritus's health condition, he was unable to travel to Arizona to resolve the matter there. And because of that, he was required to sign an interim consent agreement there, which suspends his license until the matter can be fully adjudicated. So the allegations themselves have never really been tested in the administrative hearing process. It's only the interim order in Arizona that kind of action has been taken. And the report and recommendation in this case recommends a suspension until Dr. Spiritus has full licensure without restriction in Arizona. And we would submit that such an arrangement has the potential to result in an unfair outcome to Dr. Spiritus. He could very well resolve the matter in Arizona or have it adjudicated there in a way that would require minor discipline to his license or just a reprimand with probationary terms. And if that happened, he may well be able to practice in Arizona where these allegations arose, but still be suspended here because he doesn't have full unrestricted licensure. And that the result just doesn't make a whole lot of sense from a fairness standpoint. And that outcome could very well happen. Negotiations are happening in Arizona. So I think the only fair thing to do here is for the board to either defer action until Arizona is resolved, or at least leave the door open for reconsideration or reinstatement at an application for reinstatement at the time Arizona is resolved, in a way that allows the board to then consider, hey, Arizona took a look at this. This is what they deemed appropriate, and we can base our action based on what Arizona thought, who is in the best position to kind of fully evaluate the allegations and the evidence presented. So I think at the very worst, this board should make the suspension temporary and leave the door open for reconsideration after Arizona is resolved. Thank you.
Thank you, sir. Does the Assistant Attorney General wish to respond?
I do. Thank you. So we know very little about the underlying facts in Arizona. We do know that Arizona indefinitely suspended Dr. Spiritus's license starting in 2017 and issued a default order revoking his license as a result of the Arizona Act. We also know that the only active license that Dr. Spiritus has right now is in Ohio, and he's living in Ohio. So I think the discussion about his health and him not being able to practice because of his health, I think you kind of have to put that in the parking lot right now, because while that has been said, we don't really. And so I think you have to approach this case assuming that Dr. Spiritus could come back to practice any day, because there's no limitation on his ability to do so. And what we typically do, what the board typically does in these cases, is wait for the other state that has the interim order or the interim limitation to kind of work its way through the facts, come to an ultimate conclusion, and then this board will have another opportunity to look at that, because this is only an interim action by Arizona, and say, okay, Arizona, you did X, Y, or Z to Dr. Spiritus because of the allegations. We're going to take another look at his license in Ohio. Or if Arizona absolves him or finds that he's not guilty, then you have this suspension that kind of automatically lifts because it was tied to Arizona and the reinstating clear license in Arizona. So I support the report and recommendation. I think it is the most appropriate course to take to protect public safety in Ohio right now. And I would respectfully request that you uphold the report and recommendation. Thank you.
Thank you so much. Is there a motion to approve and confirm the proposed findings of fact, conclusions, and order in the matter of Dr. Spiritus? Motion?
So moved.
Dr. Bechtel and
Second, Dr. Johnson.
Dr. Johnson, thanks very kindly. I will now entertain discussion concerning the matter of Dr. Spiritus. Is there any discussion? So I would just, if I may, echo what Ms. Snyder said. I do think it's common with cases like this for our board to take action that's consistent with the proposed order. I think it's fair. And I appreciate defense counsel's thought about active licensure as a condition of reinstatement instead of full licensure, but I think being on probation in another state is not insignificant. I would want to be satisfied as to the doctor's behavior while he's being monitored in that probationary status. So I just support the order as is. Any further discussion? Okay. Maybe then let's have a roll call vote then, please, to approve and confirm the proposed findings of fact, conclusions, and order as presented in the matter of Dr. Spiritus. Roll call, please. Dr. Rothermel.
Abstain.
Dr. Safran.
Abstain.
Mr. Giacalone.
Yes.
Dr. Sohn.
Yes.
Dr. Johnson.
Yes.
Dr. Cacarella.
Yes.
Mr. Gunadakis.
Yes.
Ms. Montgomery.
Yes.
Dr. Feibel.
Yes.
Dr. Bechtel.
Yes.
And myself, Michael Schottenstein, yes. Thank you. In the following matters, the board issued notices of opportunity for hearing and documentation of service was received for each. There were no timely requests for hearing filed, and more than 30 days have elapsed since the mailing of the notices. These matters are therefore before the board for a final disposition. These matters are non-disciplinary in nature, and therefore all board members may vote. On March 16th, 2020, the board issued a notice of opportunity for hearing to Adrienne Renee Baeza, MD, MT, informing her that the State Medical Board of Ohio proposed to deny her application for a certificate to practice massage therapy because she does not hold a diploma or certificate from a school, college, or institution in another state or jurisdiction that meets the board's required course of instruction and hasn't held a current license, registration, or certificate of good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find that the facts set forth in the March 16th, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence and that the board enter an order effective immediately upon mailing denying Ms. Baez's application? Motion?
So moved, Dr. Johnson.
Dr. Bechtel, Dr. Johnson, thank you. Is there discussion? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Mr. Gunadakis?
Yep.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. On August 12, 2020, the board issued a notice of opportunity to hearing to Samantha Michelle Badel, MT, informing her that the State Medical Board of Ohio proposed to approve his application for restoration of her license to practice massage therapy, provided that that should say, taken past the massage and bodywork licensing examination due to the fact that Ms. Badel has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the August 12, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence and that the board enter an order effective immediately upon mailing, approving Ms. Badel's application, provided that she takes and passes the NBLEX within 12 months of the date of mailing of the order? Motion?
So moved.
Dr. Safran and
Second, Dr.
Dr.
Cacarella.
Thank you. Is there discussion? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Mr. Gunadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. On July 15th, 2020, the board issued a notice of opportunity for hearing to Christopher D. Boggs, informing him that the State Medical Board of Ohio proposed to deny his application for a limited permit to practice respiratory care because applications for a limited permit must be submitted within 1 year following the date of graduation from a respiratory care educational program. Because Mr. Boggs graduated from on or about May 5th, 2018, but submitted his application for a limited permit on February 27, 2020, he is not an eligible recipient for a limited permit. Do I hear a motion to find the facts set forth in the July 15, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence and that the board enter an order effective immediately upon mailing denying Mr. Boggs' application? Motion?
So moved, Dr. Johnson.
Dr. Johnson, Dr. Bechtel, thank you. Is there discussion?
Discussion.
Mr. Giacalone?
I'm a little confused because he graduated in 2018. He applied in 2020. There's a 1 year requirement after graduation to get licensed. Does this mean he's totally out of the game? Unlike, people in the NAPLEX and other places that can take an exam, there's a clinical simulation exam. Why can't he take that to be licensed? Because right now, the way it stands, he's in a catch-22.
Yes. I don't know if Joe's around to opine on this, but my thought was that, because I wondered about the same thing, I think it's in statute, that it's how the statute is written. I don't know if Kim, you have any thoughts about that?
I don't, but I'm looking.
Well, can we table this one? Because that's my only concern is this guy essentially went to school and he's done. There's no way to get back in for this if that's the case. Whereas if you do it for medicine, you're out greater than 5 years, you can take an with SPEX, take the NBLEX for the massage therapy, and this person gets nothing. That seems a bit unfair. But okay, that's it.
Thank you so much. We have a motion to table. Is there a second?
Second.
Dr. Sohn, thank you. Is there further discussion?
Yeah, the only one point I want to bring up. The only one point I want to bring up is, and I agree with Mr. Giacaloni's point, but I don't know about how some of these stimulation exams are being brought out now because of COVID. Because I know with some of the medical student, like the Step 2 CS and that type of stuff, have been suspended. I just wanted to make that point. It does not change my decision making, though.
Is this a motion to table, did I hear?
Yes, it's a motion to table.
I don't mean to be the parliamentarian, but I think that's a non-debatable motion by Robert's rules. So Benton, you could say.
Oh,
yes, that is correct. I'm counting Dr. Zoid's comments as to before. I kind of deferring a bit, but you are correct, Dr. Feigl.
Thank you.
Thank you all. So we have a motion to table, so we'll just vote on the motion to table without further discussion. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Mr. Gonadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Thank you very much. On July 8th, 2020, the board issued a notice of opportunity for hearing to Erin Kelly Burrell, MT, informing her that the State Medical Board of Ohio proposed to approve her application for restoration of her license to practice massage therapy, provided that she take and pass the Massage and Bodywork Licensing Examination, MBLEX, due to the fact that Ms. Burrell has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the July 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing approving Ms. Burrell's application, provided that she takes and passes the MBLEX within 12 months of the date of mailing of this order? Motion, please.
So moved.
Second.
Dr. Safran, thank you. And Dr. Bechtel, thank you so much. Discussion? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Mr. Gonadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. On March 11, 2020, the board issued a notice of opportunity for hearing to Hopi Carrington, RCP, informing her that the State Medical Board of Ohio proposed to approve her application for license to practice respiratory care, provided she take and pass the Clinical Simulation Examination, CSE, due to the fact that Ms. Carrington has not engaged in the active practice of respiratory care for more than 2 years. Do I hear a motion to find that the facts set forth in the March 11, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing approving Ms. Carrington's application, provided that she takes and passes the CSE within 12 months of the date of mailing of this order? Motion, please.
So moved.
Dr. Safran and?
Second, Dr. Cacarella.
Thank you, Dr. Cacarella. Is there discussion? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Giacalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Cacarella?
Yes.
Mr. Gonadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. On July 8th, 2020, the board issued a notice of opportunity for hearing to Andrea N. Jones, MT, informing her that the State Medical Board of Ohio proposed to approve her application for restoration of her license to practice massage therapy, provided that she takes and passes the Massage and Bodywork Licensing Examination MBLEX, due to the fact that Ms. Jones has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the July 8th, 2020 notice of opportunity for hearing have been proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing approving Ms. Jones' application, provided that she takes and passes the MBLEX within 12 months of the date of mailing of this order? Motion, please.
So moved.
Dr. Safran and
Second.
Dr.
Dr. Caparella, thank you so much. Is there discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Solon,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. On April 27, 2020, the board issued a notice of opportunity for hearing to Haley Mason, MT, informing her that the State Medical Board of Ohio proposed to deny her application to practice massage therapy because she does not hold a diploma or certificate from a school, college, or institution in another state or jurisdiction that meets the board's required course of instruction, and hasn't held a current license, registration, or certificate of good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find that the facts set forth in the April 27, 2020 notice of opportunity for hearing have been proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Ms. Mason's application? Motion, please.
So moved.
Dr. Safran and
Second.
Dr. Bechtel, thank you so much. Is there discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Solon,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. On April 27, 2020, the board issued a notice of opportunity for hearing to Brianna Lee Maria Rivera, MT, informing her that the State Medical Board of Ohio proposed to deny her application to practice massage therapy because she does not hold a diploma or certificate from a school, college, or institution in another state or jurisdiction that meets the board's required course of instruction, and hasn't held a current license, registration, or certificate of good standing for massage therapy in another state for at least the preceding 5 years. Do I hear a motion to find that the facts set forth in the April 27, 2020 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Ms. Rivera's application? Motion, please.
So moved.
Dr.
Second.
Safran and Dr.
Second.
Caparella, thank you so much. Thank you. Is there discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Solon,
Yes.
Dr. Johnson,
Yes.
Dr. Cacarella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
and myself, Michael Schottenstein, yes. On November 13th, 2019, the board issued a notice of opportunity for hearing to Brian G. Rubenstein, MT, informing him that the State Medical Board of Ohio proposed to approve his application for restoration of his license to practice massage therapy, provided he take and pass the Massage and Bodywork Licensing Examination MBLEX, due to the fact that Mr. Rubenstein has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the November 13th, 2019 notice of opportunity for hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing, approving Mr. Rubenstein's application, provided that he takes and passes the MBLEX within 12 months of the date of mailing of this order? Motion, please.
So moved.
Dr.
Second.
Second and Dr. Caparella, thank you so much. Discussion? Roll call, please. Dr. Rothermel,
Yes.
Dr. Safran,
Yes.
Mr. Giacalone,
Yes.
Dr. Solon,
Yes.
Dr. Johnson,
Yes.
Dr. Caparella,
Yes.
Mr. Ganadakis,
Yes.
Ms. Montgomery,
Yes.
Dr. Feibel,
Yes.
Dr. Bechtel,
Yes.
Myself, Michael Schottenstein, yes. On May 13th, 2020, the board issued a notice of opportunity for hearing to Erin Lee Ruskowitz Soltis MT, informing her that the State Medical Board of Ohio proposed to approve her application for restoration of her license to practice massage therapy, provided she can pass the massage and bodywork licensing examination MBLEX, due to the fact that Ms. Ruskowitz Soltis has not engaged in the active practice of massage therapy for more than 2 years. Do I hear a motion to find that the facts set forth in the May 13th, 2020 notice of opportunity for hearing have been proven to be true by a preponderance of the evidence, and that the board enter an order effective immediately upon mailing, approving Ms. Ruskowitz Soltis' application, provided that she takes and passes the MBLEX within 12 months of the date of mailing of this order? Motion?
Dr. Bechtel, so moved.
Thank you, Bechtel.
Second.
Thank you. Dr. Safran, thank you so much. Is there discussion? Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Thank you all so much.
Dr.
Maybe we could take a
Schottenstein?
break.
Um,
Yes.
So Joe Turek is available if you want to take the Christopher Boggs matter off the table.
Oh. Is there a motion to remove the matter from the table?
So moved.
Thank you. Is there a second?
Second.
Dr. Bechtel? Could we have a roll call then on the motion? Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Jackalone?
Yes.
Dr. Sohn?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Mr. Ganadakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Thank you. So the matter's off the table. Joe, do you want to proceed?
Yeah. So Christopher Boggs was an applicant for a limited permit, an L1 permit to practice respiratory care. Pursuant to the statute, you can only hold an L1 if you are enrolled in a respiratory care program, or if you graduated from a program and it's been less than 1 year since you've graduated. He graduated sometime in May of 2018. So he's ineligible to hold an L1 permit because it has been more than 1 year since he has graduated from the program. Nothing would stop Mr. Boggs from applying for a full respiratory care license, assuming that he has the RRT credential from the NBRC. When he applied for the L1, it appeared that he was only a certified respiratory therapist, a CRT. So he would need to get the RRT credential to be able to apply for the full respiratory care license. But otherwise, nothing would be preventing him from applying and getting full licensure.
And Joe, quick question.
Sure.
If he hasn't been practicing, I mean, is it another catch-22? Can he apply for that and get it if he hasn't been practicing? Or that's what I'm trying to understand. I mean, I understand within a year. You're saying if he gets his other certification, he can do it. But can he get the certification if he's been out and he hasn't done anything?
Yeah, I mean, he just needs to take the exam from the NBRC, and the board, I guess, could do something else if they thought that he had fitness to practice issues, because if he's never practiced and he's been out of school for all this time and has never really been engaged in respiratory care, the board may do something regarding fitness to practice. However, if he applies right after he passes the RRT, I'm pretty sure the board would determine that he is fit to practice. He just recently passed the exam.
Okay, so bottom line, he has a vehicle to get back in.
Oh yeah, absolutely. He can absolutely apply for a respiratory care license.
Can we make sure he understands that so he's not like, I have no other choice here. You guys denied it. Can we let him know that?
Yes, we certainly can. I will say he's been somewhat maybe unresponsive to our communications, but we will certainly try to let him know.
Okay, cool. That's all the requests. Thanks.
No problem.
Thank you so much, Joe. Is there further discussion? Okay. So I don't know that I need to read the summary of the matter again. I'll just ask for a motion. Is that okay, Kim? I'll just ask for.
Okay, if you could read the motion.
Yes, exactly. So I'll ask for a motion then, please, to find that the facts set forth in the July 15th, 2020 Notice of Opportunity for Hearing have been proven to be true by preponderance of the evidence, and that the board enter an order effective immediately upon mailing denying Mr. Boggs' application. Motion?
So moved.
Sorry.
Dr. Safran, Dr. Bechtel, thank you. Is there further discussion? Just thanks, Bob, for bringing that up. I appreciate it. Roll call, please. Dr. Rothermel?
Yes.
Dr. Safran?
Yes.
Mr. Jackalone?
Yes.
Dr. Soen?
Yes.
Dr. Johnson?
Yes.
Dr. Coccarello?
Yes.
Mr. Ganaudakis?
Yes.
Ms. Montgomery?
Yes.
Dr. Feibel?
Yes.
Dr. Bechtel?
Yes.
And myself, Michael Schottenstein, yes. Thank you. Staff is requesting we all take a break before we go into executive session. Is that okay with everybody? Okay, so want to say, what time is it? 12:39. Want to reconvene at 1? Is that okay with everybody?
You need to reconvene in open session.
Yes, we'll reconvene in open session, and I think we have a link for that from Tessie. So I'll look forward to seeing everybody at 1 o'clock. Good? Thanks.